Okay, good evening and welcome to the June 11th meeting of the Santa Monica Rent Control Board. This meeting is available on cable TV via channel 16 streaming. There's also a live stream on Blue Jeans. The dial-in number 415-466-7000 with a PIN. We are implementing these virtual meetings in an effort to stop the spread of COVID-19. On an ongoing basis, those wishing to give public comment must request via email to the rentcontrol@smgov.net by 4:30 on June 11th, 2020, or typically the day of the meeting to request to give public comment. Thank you, everyone, for tuning in. Looking forward to a productive meeting. May we please have a roll call?
Yes. Commissioner Foster.
Here.
Commissioner Trosis.
Here.
Commissioner Duran.
Here.
Commissioner Sultan.
Here.
And Chair Phyllis.
Here.
All present.
Next item on the agenda is approval of the minutes from the May 21st, 2020 meeting. Is there a motion to approve the minutes?
I move to approve.
Second. There's a second. Commissioner Trosis moved. Commissioner Foster seconded. Can we have a roll call vote, please?
Yes. Commissioner Trosis.
Yes.
Commissioner Sultan.
Yes.
Commissioner Duran.
Yes.
Commissioner Foster.
Yes.
And Chair Phyllis.
Here. Yep.
Motion carries.
Yep. Okay. Next item on the agenda is special agenda items. This is an opportunity to provide announcements pertaining to the Santa Monica Rent Control Board. Do we have any announcements, Executive Director Condon?
Good evening, Commissioners. No, I don't have any announcements this evening.
Anyone else wish to share an announcement? Okay, seeing none, we'll move to the next item, which is public comment. This is an opportunity for the public to speak to the board on any issue of general interest to the community. This evening, we do not have any public comments, so we'll be moving immediately to jurisdictional items. Our first item on the agenda is item 10A, an appeal. This is an appeal of 1321 Harvard Street from C. Chekaloff and K. Chekaloff, manager, on behalf of D. Chekaloff, landlord. It's an appeal of the officer's decision denying landlord's petition to find tenants not in occupancy of their unit under Regulation 3304. May we have a staff report, please?
Good evening, Commissioners. In this case, the tenant, Mr. Tim Ferris, moved into Unit 1 at 1321 Harvard Street back in 1992. His girlfriend, Courtney Winfrey, moved in a year later. She moved out and returned a couple times since then, most recently when she bought her own home in Highland Park in 2015, and then when she sold that home in July 2019 and moved back in with Mr. Ferris. Diane Chekaloff, who owns the property, and her son Kevin and daughter-in-law Kaylee, who manage it, claim that neither tenant resides in the unit as their principal residence. So they have filed a petition for the board to find the tenants not in occupancy and to reset their rents based on market rates. To prevail, the Chekaloffs must show that neither tenant resides in the unit as their principal residence. In filing their petition, they submitted the testimony of a neighbor, Jerry Cipriano, who said that as of late he had seen Mr. Ferris far less frequently than he used to. They submitted evidence that Ms. Winfrey owned a home in Highland Park. They stated that water bills showed a spike in usage as early as May or June of 2019, but the leak to which they attributed the spike was not reported by Mr. Ferris until August, which they contend shows that he did not live there. They submitted photos from security cameras. They said showed that the tenants were subletting their apartment and using it as an entertainment venue. Kaylee Chekaloff submitted a photo of the apartment that appeared very cluttered and argued that it shows that the tenants only use the apartment for storage. Once they had preferred this prima facie evidence that the tenants do not reside in the unit as their principal residence, the burden then shifted to the tenants to refute the evidence by a preponderance of the evidence that's in the record. The record shows that that is a burden that the tenants met. Neither tenant denied that Ms. Winfrey moved into her own home in Highland Park from 2015 through 2019, and Mr. Ferris spent time at his girlfriend's home, but he was unequivocal in his testimony that he did not live there. He estimated that he usually spent the weekend at Ms. Winfrey's and some weekends. His sister, who had lived in Mr. Ferris's unit before him and was regarded by the Chekaloffs as a very good tenant, testified that her brother always lived in the Santa Monica apartment even when Ms. Winfrey moved away. Ms. Winfrey's friend, Jennifer Huber, testified that she stayed with Ms. Winfrey for 2 weeks in 2019 in Highland Park and only saw Mr. Ferris on a couple occasions. Pablo Orellana, who did gardening and cleaning for Ms. Winfrey in Highland Park, testified that it was clear that Mr. Ferris was always visiting. Susan Patorka, a friend from New York who visited multiple times over the last several years, declared that Mr. Ferris and Ms. Winfrey always appeared to live in their own places when she visited. Another friend, Lily Marlene von Kalbach, also declared the same. The Chekaloffs argued that the tenants moved back into the Santa Monica apartment in July of 2019 only because they told them that they were filing the petition then. But Ms. Winfrey listed her house and went into escrow before July 2019, so the two events do not appear to be in any way related. Mr. Ferris' supervisor at the Hammer Museum, Jim Federley, confirmed that Mr. Ferris typically commutes to work on his bike from Santa Monica and not from Highland Park. Another co-worker, Sadie Strangio, stated that she was initially excited to see Mr. Ferris more when Ms. Winfrey moved to Highland Park. She said that because she also lives in Highland Park, but she said that that turned out to be rarely the case because Mr. Ferris was usually in the West Side. Mr. Ferris also testified that in 2018 he was away more than usual because of several medical and family emergencies. Ms. Winfrey had foot surgery in January 2018, and the two of them went and stayed with his sister during her recovery. When Ms. Winfrey had her follow-up surgery in June, Mr. Ferris went and stayed with her in Highland Park for a month. Both tenants took several trips that year to visit Ms. Winfrey's family in Arizona because of various illnesses and family deaths. As to the photos of purported subtenants from video stills from the garage security cameras, Mr. Ferris identified his friends from London who had visited him and stayed for 8 days, a friend who had come over to help pick out countertops from Ms. Winfrey's home, and a friend returning a boogie board. Mr. Ferris also denied using his apartment as an entertainment venue and said that the only party he'd ever thrown, the only party that he'd thrown recently was to celebrate his nephew's marriage. As to the leak in the patio, which the Chekaloffs argued Mr. Ferris would have reported sooner had he actually been living in his unit, the record showed, and Kevin Chekaloff confirmed, that he had actually been working in the patio area at the same time making repairs. So apparently it was a leak that he had failed to notice as well. As to the photo of the apartment as cluttered that allegedly showed it to be used for storage, Ms. Winfrey stated that Ms. Chekaloff had come in and taken that photo when she had been moving back in from after having sold her home. Ms. Winfrey then pointed to the photos taken subsequently by the hearings investigator and said that that's how the apartment actually appears after she had finished the move. The hearing inspector's report showed the apartment to be fully furnished and highly stylized with a fully stocked kitchen and bathroom, many personal photographs of the couple, personal mail addressed to them, and personal property. Government records show Unit 1 listed as Mr. Ferris's apartment as well. It's on his driver's license and voter registration, as well apparently as his DMV vehicle registration. It is listed on his renter's insurance policy and tax filings. But for the testimony of the neighbor, Mr. Cipriano, who said that he had seen Mr. Ferris much less than he had used to, the overwhelming evidence in the record supports Mr. Ferris's claim that he lives in Unit 1 and that Ms. Winfrey rejoined him there in July of 2019. In their appeal, the Chekaloffs also point out that a LexisNexis search record showed Mr. Ferris's probable address to have been Unit 1 since 1980. Mr. Ferris didn't actually move into the unit until 1992. This was a series of searches that the hearing investigator had submitted into the record. But that the search result is faulty is irrelevant to this case because the hearing officer did not base her decision on that piece of evidence. Her decision is based on the totality of the record, which shows by more than a preponderance of the evidence that Unit 1 never ceased to be Mr. Ferris's principal place of residence. For that reason, staff recommends the board affirm the hearing officer's decision and findings of fact and conclusions of law.
Okay, thank you very much. We have two speakers on this item. Our first speakers are Kevin and Kaylee Chekaloff. They have 5 minutes each or 10 minutes total, and they are also calling from the same phone. And then our second set of speakers are the tenants, Courtney Winfrey and Tim Ferris, each of whom also have 5 minutes. We'll start with Kaylee and Kevin. I'm going to elevate them from the attendees right now. Please again bear with us because there's about a 30-minute or 30-second delay.
Nicole?
Yeah.
Chair, I'm sorry to interrupt you. It's a little different tonight in that there's not that delay. And they're in the presenter queue. You can see them in the presenter queue, so just unmute them and they'll be able to speak.
Oh, great. Thank you.
They're at the bottom.
Okay. There they are. Okay. Haley and Kevin, I am about to unmute you, and your 10 minutes total will start now.
Hi, this is Kaylee Chekaloff.
Great.
Can you hear me?
Yep.
Okay, great. Okay, so we basically appealed the decision of the hearing officer because we believe that, the tenants had quite a few witnesses testify, but they all said that they were all basically family and friends. None of them were neutral witnesses. And we thought that because we had a witness that was completely neutral, a neighbor that knew both of us and knew the tenants and us, but was basically just a neighbor, not a friend of any kind, that his evidence basically was more basically should have been weighed much heavier than their witnesses' testimony. Jerry Cipriano basically said that he used to see the tenants regularly, but about once a week. And he's retired. He's at home most of the time. And then in the past few years, he didn't see them very often at all. Basically, I think he said twice since about 2015 on when Miss Winfrey bought her house. And Mr. Ferris said that that he wasn't there because he was at work most of the time, but and he had his boss be a witness and say that he was at work most of the time as well, but they didn't state a certain date that his work schedule changed. I mean, he basically said that I think that it was like the past 10 years they'd worked together at least, and that they'd been, he'd worked the same hours. So that didn't really make sense that his schedule would change so drastically, 5 years ago. So we thought that was a good point, and having a witness that was neutral would, way heavier in our favor. So none of their witnesses were unbiased. That's basically the main point I wanted to make. Did you want to say anything?
I just had a question for the board. I wanted to know how many of the board members sitting there right now are renters?
What if I could just interrupt very briefly? Under the board's regulations, it's out of order for persons appearing before the board to question the board. So there's no obligation to entertain questions. This is an opportunity for somebody to present their argument.
Well, I mean, we know that absolutely Tim Ferriss did not live there because we were there for 4 years and we rarely leave home. And he absolutely was living over in Highland Park with Courtney Winfrey, and they were both involved in renovating the home over there. And I mean, we went over, spied on them, and we saw they were both living there. And we asked around, and we know they were both living there. And again, we got a preposterous, the person that was in charge of making the decision, our hearing officer, made a decision and found in favor of the tenants. And I'm sure, I don't know how often landlords win these sort of things when a petition is made, but as soon as we filed the petition and let them know that it was going to be filed, they moved back in, and we watched them move back in frantically and make it look like they had been there the whole time, which they had not. And we have tons of video evidence, and we know. I mean, he didn't live there. His fountain ran dry constantly. Weeds were growing in the patio of his place. There was no one there, and yet we get this, ludicrous, completely ludicrous result of a petition we spent many hours putting together, and security cameras support our findings, and it's just, I find it very hard to believe that the small landlord, small business owner, operator ever wins in these petitions, because we had solid evidence, and we had an unbiased, neutral witness that was friendly with both the owners, us, Kaylee and Kevin Chekaloff, and my mother, and also friendly with Tim and Courtney. We had video evidence showing them talking. He absolutely came in kind of as a surprise, because we asked him, and normally people don't like to get involved in other people's problems, but in the end he showed up and he told the truth. And he absolutely stated that, he didn't really want to do it. He even said something like, "But Tim's my friend." But he came in, and once he heard that we had no witnesses, he came in and he told the truth and said that for the past several years, he barely ever saw either Tim or Courtney. And, well, again, we get this result that doesn't match the evidence, and really, that's all I have to say. I mean, I asked a question, I put a question in front of the board, but I guess you guys refused to answer it. But let that hang in the wind, because I think in this country, democracy is supposed to be the way things work, with a fair representation of, the people that are involved in these sort of cases. But I don't think it's like that. I think most of the people on that board are renters. I really believe that. I don't know what else to say, but this is our appeal.
Mr. Chekaloff, we have a few questions for you.
Okay.
So first of all, I'd like to clarify, I'm the chair of the board. I'm a renter.
Okay.
I've been a renter since I moved to Santa Monica. Certainly nothing to hide there. That was part of my platform when I ran in 2014, also part of my platform when I was reelected in 2018. I think a modicum of research on any of the other board members here would make it very easy to figure out who is a renter and who is not. Been publicly stated. So just want to make it clear on the record that even though this has absolutely nothing to do with your appeal, we have nothing to hide, and I'm pretty sure you could find all of that information yourself. With that, I believe Commissioner Duran has a question.
Okay.
Actually, I don't. I'm sorry. I was ready for a discussion. I don't have a question for the.
Okay.
Thank you.
I have a question for Mr. Chekaloff. I have a couple. So my first question is, you mentioned that you spied on your tenants.
No, there's no spying. You made us look like creeps last time because we have security cameras up, and those security cameras come in handy. They helped Tim once when he got one of his packages stolen, and he asked to see them, and I handed over. He could have come over and watched the whole feed, but instead I took a bunch of photos, stills, showing the perpetrator that came during the night and stole one of his packages. They're actually security cameras, and by the way, the people in the back, Unit 6, also had a break-in, and they ended up putting bars on their windows because of the break-in. And we didn't have security cameras at that time, but after that, we had put the security cameras in because there's all kinds of homeless people and there's all kinds of creeps running around all the time, and it really helps in solving mysteries and stuff. We don't sit around and watch the cameras.
You're kind of going
like you.
No, I'm going to mute you if you cannot respect this process. Nope, you are out of order, and you are out of order. This is a question-answer period. If you are not going to
I'm still answering the question.
Okay, I'm done with if the witnesses cannot participate in the process, it's really unfortunate, but this is a civilized meeting. I had some questions. I'm going to give Mr. Chekaloff a chance to calm himself down and return in 10 seconds. I hope that he will focus on answering my questions. I do have a specific question about his appeal, but if he uses abusive language or speaks over me, I will cut him off. Mr. Chekaloff, I'm going to unmute you to ask a second question. Thank you. My second question is, from all of the evidence that you have, do you believe that the tenants left for a significant period of time to indicate that they did not intend to return?
They were gone yes. The answer is yes. They were gone so long that I felt as if we had no neighbors on either side of us. In fact, the neighbor directly adjacent to the front building, had never seen or met Tim Ferriss before that time in 2019 when they moved back in. It was July or August when their house went into escrow and closed very quickly. They had no problem selling their house, Highland Park, after they renovated it.
Sure. So what's your best evidence that they intended to reside in the Highland Park house if they were renovating it for the purpose of sale?
That they were never home. They were never home. They live. We share a wall, and there was no one there.
Okay.
And here's one other point. Tim said he had a crash pad on the east side. He was trying to minimize it. I asked him once, Tim, it's no secret that you're not around very much, and he said he had a crash pad on the east side.
Okay, great. Thank you, Mr. Chekaloff. We will move to our next speaker in the queue.
Okay.
Thank you. Our next speakers are Ms. Winfrey and Mr. Ferris. You will have a combined opportunity to speak for 10 minutes. I know you're speaking from the same phone. I'm going to unmute you now.
Hi.
Hi.
Hi. I'm Tim Ferris. Thanks for giving us this opportunity to speak with you. Okay. As noted in the staff report, we've proven by more than a preponderance of the evidence that I live at 1321 Harvard Street, apartment number 1, and have continuously lived in this apartment for over 25 years. I've supplied every single document and satisfied all criteria that the Rent Control Board requests in order to prove occupancy. The Chekaloff's allegations that I am in non-occupancy are fantasy and invention. They've accused me of everything from subletting my apartment to using it as storage, using it as an office space, and even as an entertainment venue, with no proof to back any of their baseless claims. I feel these landlords have acted shamefully. They've manufactured evidence out of completely normal situations and perjured themselves on numerous occasions in their disingenuous attempt to triple my rent. Throughout these proceedings, the Chekaloffs have shown little regard or respect for the board or their tenants. This feels very much like harassment and just a scheme to make more money. That's all I have to say. I'm going to pass it off to Courtney now.
Hi, thank you. As Tim, whom I call Sugar Pie, mentioned, we have indisputably proven in every legal way possible that Harvard is and has always been his usual residence of return since 1992. We have indisputably proven that he works so close to his apartment that he rides his bike to work. We have indisputably proven that he works 2 jobs with long and varied hours. And we have had 9 people unambiguously testify to and or declare that he did not live in the house I purchased 5 years ago and sold last July. I worked and lived on the east side. Sugar Pie works and lives on the west side and always has. And because we have disproven every single accusation and bogus claim the Chekaloffs have made, they are now grasping at the thinnest straws imaginable. Kaylee wants you to think there's some great conspiracy about Sugar Pie's car not being in the driveway when Ms. Woodnicki came for the inspection. As C. Riles notes in her decision, it is undisputed that Sugar Pie's car is registered at the Harvard address. We provided that document in our initial response to the petition. The reason it was not in the driveway on that particular day is because I took it to work. After driving to Arizona numerous times to see my dying brother, I was on target for going over my mileage allowance. So often, when Sugar Pie would ride his bike to work, I used his car. It's not a mystery. In her appeal, which, if it wasn't so disruptive to our lives, would be laughable, Kaylee suggests that more weight be given to the vague testimony of a man who lives on our street than to all legal documents and 9 witnesses and their declarants. Gary Cipriano was indeed an impartial witness, but he's hardly an expert. Expert at what? Keeping tabs on his neighbors? Haley stated that Jerry should notice any changes in Tim Ferriss's routine. That's putting quite the burden on a man with whom we have almost zero interaction. Mr. Cipriano admitted he didn't know Sugar Pie took a full-time day job at the museum almost 4 years ago. Even more relevant, Sugar Pie doesn't have a routine. His hours are extremely varied and long. He has a full-time job, a part-time job, and he picks up extra work regularly. He has no routine to speak of. Mr. Cipriano never said this all changed drastically in 2015 when Tim moved out. All Mr. Cipriano testified to was that he could not definitively say anything about whether we lived at the subject unit and that he knows nothing about our work schedules. He stated that he only ever saw Mr. Ferris in the late morning or afternoon, which now that Sugar Pie works full-time at the museum are hours that he is almost never home. What Mr. Cipriano may or may not have seen carries no weight at all in light of all of our evidence and Kevin and Kaylee's own admission under oath that they saw Sugar Pie every week or two between 2015 and 2019, which C. Riles notes on page 32 and 55 of the decision. Kaylee went on to characterize Sugar Pie's excuses for his absence as specious. Not only is she confusing Jim Federley's testimony, which details Sugar Pie's full-time job of the last 4 years, not the part-time work he did for the 7 years prior, but she is minimizing all of the incredibly difficult situations in my life, which has required Sugar Pie's absence from his apartment. Her trivialization of my family's misfortunes as specious is nauseating. Knowing full well that Sugar Pie was always living at the apartment because they saw him regularly, the Chekaloffs, through their pernicious attempts to mislead, outright falsehoods, and deliberate misrepresentations, have unmasked the depth of their chicanery. They have used their right of access and interfered with our right to privacy by entering our apartment without notice and taking photos of our personal belongings in an attempt to collect evidence to be used against us, a direct violation of Municipal Code 45620. They lied under oath multiple times, saying they entered our home only once because of an alarm. Their own submitted photos prove they entered on at least 2 occasions. They testified that a worker at my house said the house was owned by a Senor Tim, which under cross-examination they admitted was not even remotely true. They accused us of having lights on timers, which they also admitted was not true. And they alleged that I sold my house because I received the notice of intent to file, when in fact they mentioned that my house was for sale in their notice, so they already knew it was for sale. So again, a deliberate attempt to mislead. For the record, my house was listed for sale in June of 2019, and I entered into a contract with a buyer on July 9th, 2 days before the notice of intent to file was even served. I moved back to Harvard in July, and it again became my usual residence of return, before Petition 274 was actually filed in August. Like the 8 surveillance cameras stationed around the property, the appellants are trying to use the Rent Control Board as a weapon to harass us. These spurious and wholly unfounded accusations cost us time, money, and peace of mind, and it's just the latest in their ongoing attempts to intimidate us out of our apartment. We respectfully ask that you affirm the hearing officer's decision that we are indeed tenants in occupancy. Thank you for your time.
Thank you, Ms. Winfrey. That will conclude public comment on this item. We have 2 commissioners who wish to speak. First, Commissioner Duran and Commissioner Trosis. Commissioner Duran.
Thank you, Chair Phillips. I wanted to say that, after reviewing the documents, to me, there is a preponderance of the evidence that shows, well, let me back up by saying we're here on an appeal. And we can only change the decision unless there's clearly erroneous decision by the hearing examiner. And to me, it seems clear to me that there was a preponderance of the evidence that showed the hearing officer's decision was a reasonable one, which isn't to say that there was evidence on both sides that was reasonable. The standard is whether the decision by the hearing examiner, if that decision was a reasonable one, and based on the evidence that I've seen, I think that it was. So I feel that, I'm ready to affirm the decision of the hearing examiner on this. Thank you.
Thanks, Commissioner Duran. Commissioner Trosis, just before you jump in, I want to make sure that we're applying the right, the standard. I think I heard you say this, Commissioner Duran, but I just want to make sure that our record's absolutely clear. It's a substantial evidence standard. The only basis that we can reverse on is if no reasonable fact finder could find the same facts based on the evidence in the record. I'm almost positive that's what I heard you say, but I just, since this is an appeal, I want to make sure the record's crystal clear. Commissioner.
Yes, you did. Yeah, that's what I intended to say. You said it more eloquently than I did.
Yep.
Commissioner Trosses.
Yeah, so I believe that Commissioner Duran did state it correctly. I, too, am not convinced on appeal. I don't see that there was a clear error made. I would also like to state that a tenant not in occupancy requires no intent to return. And I don't even care. You can say that someone has a crash pad, that they're going, that they're with their girlfriend, etc. But clearly, I can see from the record and from the commentary that there was always an intent to return. I don't ever see that there was an abandonment. And quite frankly, credibility of witnesses is very important. And just given what I've heard here today, I think that speaks for itself for me. And I don't really buy anything pertaining to a neutral witness versus non-neutral witnesses. It's about, everyone has a bias. It's about credibility. So I don't see that. I mean, to me, this is crystal clear, and quite frankly, it seems like there's a pattern going on here with these appellants. So I'm a little concerned, just going forward, for any future tenants that live in this property, and I'm a little concerned about the allegations of spying. I don't think that that's appropriate either. So I would be a little bit more careful in putting my case together in the future, because I'm sure we're going to see a future one. But to me, I'm ready to go with what Commissioner Duran stated, and I'm ready to affirm, and I can make a motion or hear from others.
I'd like to quickly recognize myself. I want to echo the concerns of Commissioner Duran and Commissioner Trosses. I think the evidence is clear in the record. Even if we were reviewing it de novo, which we are not, I would rule the exact same way. I also think, when people play the tape back, they will hear that the appellants admitted that they were spying on their tenants. And I think that that's a pretty significant admission unrelated to this appeal, but does bear on their credibility. So I'm ready to vote if there is a motion.
I'll make a motion to, okay, Steve should move. Commissioner Duran should move. He stated it first.
Sure. I move that we affirm the hearing officer's decision and
Uphold the findings of fact and conclusions of law.
yes. After 7 years, you think I would get that, but exactly what Commissioner Trosses said.
Okay. There's a motion by Commissioner.
Second.
Yep. May we have a roll call vote, please?
Yes. Commissioner Duran.
Yes.
Commissioner Foster.
Yes.
Commissioner Salton.
Yes.
Commissioner Trosses.
Yes.
And Chair Phyllis.
Yes.
Motion carries.
Okay. Next item on the agenda is an appeal about 1045 Ocean Avenue, Unit 12. The appellant, Mr. Bongartz, is the tenant, and the tenant appeals the hearing officer's denial of a rent decrease for alleged reductions in housing services. May we have a staff report, please?
Commissioners, rent is presumed to be fair when it is negotiated in the unrestricted market. Housing services are the basket of goods that are paid for by that rent when it is initially set. Maintaining those housing services ensures that the rent remains fair. High courts have recognized the board's authority to decrease the rent if a landlord substantially reduces housing services because it keeps the rent fair. Under Santa Monica's rent control law, for tenancies that were established before 1999, the rent is based on the rent that was charged for that unit on April 10th, 1978, a year before the law's adoption, because the law presumes that that rent was fair because it was negotiated in an unrestricted market. To ensure that the rent remains fair, the board is authorized to decrease the rent if the landlord substantially reduces housing services to which the tenant was entitled on April 10th, 1978, when that rent was set. In this case, the tenant, Mr. Bongartz, moved into his unit in 1979. When he did, and for years later, the landlord let him use 2 storage spaces. 20 years ago, the then landlord took one of those spaces back for his own use. Mr. Bongartz 5, but then the landlord took the space back for his own use, then to make some repairs in that area, and currently under the new landlord, that one space is being used. Mr. Bongartz filed a petition for rent decrease because he asserted the second storage space was a housing service of his tenancy. To be entitled to that decrease, he bore the burden of proving that a second storage space was an amenity of the tenant living in his unit on April 10, 1978, because that's when his rent was set. He failed to produce any evidence that showed that to be the case. In fact, the only evidence in the record on this question is the 1979 registration form by his then landlord that lists the amenities for the 1978 tenant and specifically does not list storage to be such an amenity, even though that's an option. Because he failed to meet his burden, the hearing officer denied his petition for a rent decrease. The board may reverse that decision if there is no reasonable basis for the hearing officer to have decided as she did given the record. In his appeal, Mr. Bongartz focuses on an email written by the neighboring tenant who uses the storage space now, Ian Brooks, in which he wrote that he had used that storage space since 1991. Whether Mr. Brooks's claim is true or not, it is irrelevant to the hearing officer's decision and the question central to this case, which is whether the second storage was an amenity of the 1978 tenant. Mr. Bongartz also objects to the fact that during the online testimony of Manager Trementine, he apparently asked Manager Mullen about the total number of storage spaces on the property. Mr. Trementine then relayed that information to the hearing officer. Mr. Bongartz questions what right Mr. Mullen had to participate in what he calls a, quote, closed hearing. The hearings on this question by Mr. Trementine constituted hearsay evidence, which is permissible but cannot be the sole basis of finding, which it wasn't. And even if it had been, it is irrelevant to the only question that matters in this case, which is whether storage. Finally, Mr. Bongartz alleges in his appeal that portions of his lease, which are now illegible, show that he is entitled to 2 storage spaces. But that Mr. Bongartz's 1979 lease may have said that he can use 2 storage spaces, an allegation that's not even proven by the evidence, is again irrelevant to there being a housing service of his tenancy that would entitle him to a rent decrease, because his rent was not set by his lease, but rather by whatever rent and amenities the tenant had in his unit a year earlier. Because the only evidence in the record on this question shows that storage was not an amenity, the hearing officer reasonably denied Mr. Bongartz's petition. Staff therefore recommends to affirm her decision and findings of fact and conclusions of law.
Thank you. We have 2 speakers on this item. First, we will hear from Mr. Bongartz, who is the appellant, and next in the queue is Mr. Tremontin. Both of you have 5 minutes, so we'll start with Mr. Bongartz. I'm going to unmute you now.
Thank you for your service.
Mr. Bongartz? Hi.
Hello.
Hello.
Hello. My name is Gary Bongartz. Thank you for your service. I understand the 1978 thing, and what I'm going to do is go over the appeal consideration. Do you have that in your possession?
Yes.
Very good. I don't want to make it lengthy, but I do want it to be clarified. With a singular email, Mr. Brooks claims he was in possession of that space at the time does not coincide with Mr. Lee's personal possession or my own documented possession. His email, Brooks, is not supported by any documentation other than his source. In other words, there's nothing on his lease or nothing from 1978 that says it's attached to his apartment, which he didn't move in. Question, on what date and by whom did the transfer of storage and keys occur? Is there an amendment or an amendum to Brooks' lease that shows he has right of possession at any time? This has not been included in any point of arbitration, hearing, or even introduced as evidence supporting his claim. Brooks' lease or any other right of possession has not been submitted as evidence or proof. Number 4, Unit 16 is Brooks' unit. It does not meet the requirements or amenities due on April 10th of 1978, according to his own email. It states that he has been in possession for 29 years. The years, 15 of those years, 5 and 11, were controlled by Dr. Lee for his personal use, taken directly from me as in my evidence presented earlier. Again, the laundry room storage created by Adam Hand with consent and agreement with Dr. Lee approximately 12 years ago in 2008. How does he still maintain that evidence when that's not on his lease, whatever? I was made aware of that by the resident manager who said, go in the basement and you can use that space. It had already been taken. Is that part of his lease or part of his agreement or somewhere substantiated, or is he just in that location? I'm 70-plus years of age. I've resided at 1045 Ocean Avenue for 41 years. I've been in documented possession of the 2 storage units, northwest and southeast, for all of those years, excepting those in which the Lee family took repossession. The verifying agreements and secreted and monetary considerations were written on the reverse of my lease, and one were secreted, meaning Dr. Lee never surrendered them with many verbal requests, never surrendered them, never told me to them, and 2, they were obliterated completely. Everything that describes he was going to pay me the money, he was going to do this, he was going to do that, I was always there, and I still kept one of the units during some of those times. This is a lack of integrity and due diligence by the parties involved. They didn't. It wasn't clear. It was all my evidence. Everything, the agreement we made after 1978 was dismissed or destroyed. I'm aware of the 1978 amenities and the relation that this has to the spaces that it dictates. Is there a special, private, or hidden agreement that uses haranguing, profanity, harassment employed by the resident manager, Singh, in an attempt to influence his gain the use of my balcony space that led directly to the discovery of the laundry rooms used by Brooks? SMPD was called, see the enclosed timeline that stated that. Since that time, I have had no contact with Mr. Singh, the resident manager, who has not been here for the entire 2 months of the COVID at all. 2 nights ago, we had a water breakage. 3 nights ago, we had a water breakage. Nobody knew about it until 3 days later. Consider today's market rate is approximately 8 times. That means I pay $950 approximately for my apartment. That apartment, all units like that, are now in the area of $2,000. The hearing officer made a statement which was inadequate, and I showed her current rates to have the same spaces in the city of Santa Monica, which run in the area of $150 to $200. I did not accept her offer. 8 years, my rent has gone from $250 to $2,000. The apartment, the space rent has gone from, at a minimum, at a bare minimum, which Dr. Lee offered me and wrote with my signature on the back of his lease, again obliterated, $5 a month, which he quit paying as soon as he felt like it. I'm not pointing fingers at anyone in particular. I'm just saying there's a lot of things here that are unanswered, that are undocumented, compared to 40 years of documentation that I've presented, versus one email that says, I've had this apartment for 29 years, which doesn't make sense. Running short, thank you again. Your consideration is appreciated.
Oh, okay. Mr. Bongartz, thank you. You can finish your thought.
It's just, as I said, I've been here 40 years, and I've had the northwest storage unit for the majority of this. He took back one. If you look through the, just a moment, please.
Mr. Bongartz, I don't mean to interrupt you, but it sounded like you were trailing off a little bit. We might be having some technical difficulty.
I missed some of the Mr. Quinn's statements as well. I've been a resident here for 40 years, or 41 years. For 25 of those, I've had complete possession of those units with documentation, with papers, and considering the obliteration of the agreement I had with Dr. Lee. Dr. Lee was just a person, a vengeful person. I don't mean this, I just said it. And everything he did was applied against anyone that he could get a foothold. And when he wouldn't surrender my lease with those numbers on it, and it was transposed to the receiving company, it was lost and obliterated. All my supporting evidence, as well as letters to him, letters to the board, suits to him, outweigh what I see as a singular email saying I have been in possession from Mr. Brooks for 29 years, which is wrong.
Well, thank you, Mr. Bongartz. We really appreciate your public comment tonight. Since it looks like we may have one question.
Ma'am, excuse me, may I? I'm an old man, okay? Ma'am, I'm an old man. This is a fight. This is very hard. I respect what you're doing. I understand our situation. But this is a fight that does not, to me, take the place of personal face-to-face testimony and, your consideration. You're doing the best you can. I'm trying to appreciate that and trying to do the best I can.
Thank you, Mr. Bongartz. I'm going to put you on mute now. Thank you for your participation. I promise you that we are all taking this extremely seriously. We're going to hear from Mr. Tremonton right now. Mr. Tremonton, you are going to have 5 minutes.
Good evening, and thank you for the time. I signed on to this. This is the first of these appeals I've been a part of. I guess I was expecting to respond to new evidence, but I don't think any was presented. I guess I would just say that the documentation that we received when my client purchased the building is all that we have. We didn't do any obliterating of the sort that's being alleged here. But that I have nothing to add. I guess I signed on just to respond, but there's nothing really new to respond to. So I'll give back the time.
Thank you, Mr. Tremonton. Does anyone wish to speak on this item? Commissioner Foster.
Thank you, Chair. We received these reports about a week in advance, just like the public. And when I read this case, I called staff to ask a question not only about this case, but about these cases in general. And I said, to even a layperson with a even cursory knowledge of the law, it would seem that if something was agreed to and had possession for so long and this, that, and the other, that would be the case and that would be proving somehow. And the staff member said, let me stop you right there. It's not that you're right or you're wrong. It might very well. There could be something scratched on the back of a lease. There could be something in possession for 40 years or 18 years or 20 years. But the problem is that I think a lot of citizens of Santa Monica and landlords of Santa Monica think that our job as a board is one thing, and instead it's actually entirely another. We are not allowed legally, by law, our charter, to adjudicate the terms of a lease between two parties. We are not. So it's not that we do or don't believe, the tenant about having possession of this storage unit. It's not that we don't believe you. It's not that it's not relevant in your life. It certainly is. And it's not that you don't have a potential case outside of this venue. but the law in the rent control charter of Santa Monica says that we are not allowed to get involved in the terms of your lease. And that is the point here tonight. We only have the charter, and the charter says that the amenities listed in 1978 are what is listed. And we don't have the authority, no matter how sympathetic we find a tenant or a landlord's case, to get involved in the details of their lease or of their contract between the two parties. And so tonight I am going to rule in favor of dismissing the appeal and finding that the staff report was correct to the letter of the law. And again, I hope I've made it clear that it's not about the details of your case or anyone's case. It's about our law and how we have to follow it. Thank you.
Okay.
If there's no one else, I can move that.
Okay. Commissioner Foster, do you have a motion?
I move that we deny the appeal.
And affirm the findings of fact and conclusions of law?
Yes.
Okay. I'll second that. May we have a roll call vote, please? Looks like we might be having some technical difficulties with the roll call vote. I will.
Yes.
Oh, okay. So I'll do a. Let me just call everyone's names so we have a clear record. Commissioner Terosis?
Yes.
Commissioner Sultan?
Yes.
Commissioner Duran?
Yes.
Commissioner Foster?
Yes.
And Commissioner Phyllis? Yes. Motion passes. We are on to our next agenda item, which is item 11A, consideration of a $32 ceiling on the 2020 annual adjustment of general adjustment of 1.4%. May we have a staff report, please?
Yes. Good evening, commissioners, once again. At your last meeting, the board asked the general counsel to include in this staff report a brief analysis of whether the board is required to announce this year's general adjustment in conformity with the formula set forth in the charter, or could instead impose a rent freeze as some other rent control jurisdictions have done. So I'll begin with that brief analysis. The rent control law set forth in Article 18 of the Santa Monica City Charter grants to the board no discretion over whether there will be an annual general adjustment in a given year or what percentage that adjustment will be. Rather, Charter Section 1805 mandates that the board calculate each year's general adjustment in accordance with a prescribed formula and then announce, not decide, the product of that calculation. Like the rest of the Charter, this provision was enacted by voter initiative, and under the California Constitution, neither the legislative nor the executive branches, including any administrative or regulatory body, may alter, overturn, disregard the voter-enacted legislation. Based on this principle alone, the board has no authority to do other than what the charter expressly calls for. But even if the charter had not been enacted by voter initiative, the board would still be bound to apply it as written. And that's because, as a regulatory body created by statute, the board may do only those things that the legislation that created it permits, and must do everything that that legislation calls for. As the Supreme Court held in 1962, and as the Court of Appeal affirmed specifically with respect to this board in 2004, it is fundamental in our law that an administrative agency may not, under the guise of its rulemaking power, abridge or enlarge its authority or act beyond the powers given to it by the statute which is the source of its power. Because many other government agencies and officials and government bodies have enacted emergency regulations and issued emergency orders during the current emergency, the question naturally arises, why can they do those things if the board can't? And the answer is that they have specifically been afforded that authority by statute. The California governor has been able to suspend certain legislative enactments only because the California Emergency Services Act, or CESA, set forth in the government code beginning in section 8550, has granted him the authority to do so. CISA also includes express authority for cities and counties to issue emergency orders and regulations. But those emergency orders and regulations cannot be issued by just any city or county official. They must be issued only by duly created disaster councils or by the governing body of that city or county. They have the authority because it has been granted to them by statute, and absent that statutory grant of authority, they would not have it. The board is not the governing body of the city of Santa Monica, and for that reason has no emergency powers. Nor does any other state law grant emergency powers to a municipal administrative agency. So the board's emergency powers, if any, must be found in the statute that created it, the city charter. And as noted above, nothing in the city charter from which the board solely derives its authority grants it such powers. To the contrary, the board's powers are circumscribed by the charter, which lists only 15 things that the board may or must do. And one of those things is to, quote, make adjustments in the rent ceiling in accordance with Charter Section 1805. Under which, as noted above, unquote, under which, as noted above, the adjustment is made according to a mandatory formula. Under the mandatory formula for determining the general adjustment percentage set forth in Charter Section 1805A, the 2020 annual general adjustment is 1.4%. The board has no discretion but to announce that percentage adjustment. But the board does have discretion under City Charter Section 1805B to impose a dollar amount limit to the annual general adjustment. Should the board elect to impose a dollar amount ceiling, it must do so following the methodology prescribed by that charter provision. That methodology is as follows. 1, determine the 85th percentile of the maximum allowable rent of all controlled units. 2, determine the 85th percentile of the maximum allowable rent of all controlled units with a base rent established before January 1, 1999. And 3, average the two rents arrived at steps in 1 and 2 and multiply that amount by the annual general adjustment. Under this methodology, the dollar amount ceiling on the 2020 general adjustment would be $32 should the board elect to impose it. Staff expresses no view as to whether the board should impose a dollar amount ceiling and has provided for the board 2 alternative resolutions. One that simply announces the 1.4% adjustment, and one that announces that percentage adjustment and also imposes the $32 ceiling. Thank you.
Thank you. We have no speakers on this item. So we'll be moving into discussion. Does anyone wish to speak? Okay, we'll start with Commissioner Trosis.
So I think this is pretty clear. We do this every year. The calculations look great. I don't have any issue. We've talked about this general adjustment of 1.4%. Given the work we've done on capping pass-throughs and given the kind of tenuous economic situation right now, I'm inclined to impose the ceiling and the 1.4% general adjustment. So as described in alternative 2 in the staff report.
Thank you, Commissioner Trosis. Does anyone else wish to be heard or make a motion?
I can make the motion if no one wants to be heard.
I'll weigh in. Again, I thought long and hard this year, and had a communication with Commissioner Foster, who I think also spent a lot of time reflecting on the significance of the current economic crisis and pandemic. This is a hardship for many people in our community. And I think it's an appropriate time to kind of, Commissioner Foster really prompted me to do this, but take pause and take stock of what we should be doing to help our community and identifying different segments of our community that need help, both tenant and housing provider alike. On balance, I was also moved to impose a cap, in part because I think many tenants, particularly tenants who may be in that income bracket, where they may have initially afforded a $2,000, $2,500 rent per month, may be priced out of receiving any sort of relief from the federal government aside from, potential unemployment, if that's a consideration. People are facing salary cuts. People are facing furloughs. Tenants do not have equity to draw upon during a crisis. So, I think many people are even people who may have initially been able to afford those rents are living on a razor's edge. And I think it's particularly timely right now to impose a cap, even though our rent increase is relatively modest. So I'm in agreement with Commissioner Trosis. I also want to thank Commissioner Foster for really pushing me to think thoughtfully about this. I think sometimes it's hard for members of our community to know what we are doing to prepare for these meetings and to understand all the things that we are considering. But I hope folks know that we take our obligations seriously. And in particular, I think Commissioner Foster has been very thoughtful. So I thank her for her thought leadership on this. I thank Commissioner Trosis and all of my colleagues on the board. I'm ready to hear a motion whenever anyone's ready to make it.
I'm happy to do it. It sounds like Commissioner Foster, did you want to say anything? Okay. I'm ready to adopt resolution 20-002, announcing the 1.4% general adjustment for 2020 and imposing a $32 ceiling, which would be Exhibit B to the staff report.
I'll second that. May we have a roll call, please?
Yes, Commissioner Foster,
Yes.
Commissioner Sultan,
Yes.
Commissioner Duran,
Yes.
Commissioner Trosis,
Yes.
and Chair Phyllis. Motion carries.
Okay. Our next item on the agenda is consideration and adoption of the Rent Control Board fiscal year 2020-2021 operating budget. May we have a brief staff report, please?
Yes, you may. Tonight, the board will hold a public hearing on the proposed budget for fiscal year 2021. The board reviewed the budget and agency goals on May 21st and supported staff's recommendations. For fiscal year 2021, we are projecting expenditures of approximately $5,287,000 and revenue of $5,253,000, resulting in a small projected deficit of just over $34,000. The budget maintains the current operations of the agency and ensures the provision of the highest level of public service in our day-to-day operations. It includes funds for 2 newsletters and the summer mailing, plus 1 additional mailing to inform property owners and tenants about the enhanced services and processes available through the agency's new property and rent tracking system that will be launched this fall. We anticipate presenting 5 or 6 seminars throughout the year, including a tenant seminar in Spanish and a new seminar on the rent tracking system's functionality. The budget also includes funds for 1 to 2 board meetings per month. For the 4th year, the budget is funded by a $198 per unit annual registration fee that will cover the board's reasonable and necessary expenses. Owners who pay the fees in full by August 3rd may pass through half of the fee, or $8.25 per month, to the tenants. I won't go over the comments I made about staffing on May 21st, but as I mentioned that evening, there's a high probability that we will be able to fill 2 of our 3 vacant positions with highly qualified city employees who are being laid off due to the city's restructuring of services and programs. Given the city's timing, we will be hiring these employees a few months earlier than originally projected, and that will result in increased expenditures. If other savings throughout the year do not cover these increased costs, the board's reserves are sufficient to do so. The budget document includes details about each budget line item and revenue projections and is available on the board's website at smgov.net/rentcontrol. A cover memo with the document highlights several specific line items that we went over in May. So before the public hearing, I wanted to just thank Ms. Noseworthy, the budget coordinator, for the excellent work and hard work she does in preparing and monitoring the budget each year. And as I've mentioned before, she's been assisted by Mr. Gwynn in recent years, and I also want to thank him for his increasing support on this effort. If the board has any questions, Ms. Noseworthy and I can answer them. Otherwise, you should hear from the public, and unfortunately, I don't think we have any public speakers on this item. So then the board should consider and adopt the proposed budget for fiscal year 2021. Thank you.
Thank you. Does anyone wish to speak? Did I see Commissioner Trosis? Commissioner Trosis.
Great. Thank you, Ms. Condon. I'm wondering, it seems like since we've taken our meetings online, there's been a lot less public comment. And I'm just wondering, like, is this having a chilling effect on public comment? I would think that we would have more public comment because it would be easier and people would not have to drive down to City Hall to come make such a comment. And this is our budget, and the budget is budgets for all agencies, municipal agencies, or something that are being scrutinized here. So I'm surprised we have no comments. So is there a way to make it easier or more clear for people if they would like to make a comment to us?
Well, we do.
Or is it easy?
I'm sorry, we publicize the meeting, the public hearings. We have the documents and the agenda posted on our website. You'll recall that in recent years, we have not had a lot of commentary on the budget or the general adjustment. So we will do everything we can to encourage public participation. I'm hoping that in the not too distant future, we might be able to return to in-person meetings, although we just have to follow the public health orders about that. But I understand your concern, and one of our goals this year is to really try and increase our communication efforts using more current technology, and the new database will give us some opportunities in that way as well with respect to email communications and things. So we are working on that and moving in that direction.
Yeah, and I would just say that my sister's moving to Santa Monica with her husband next week, and she called me up and she said, "What's going on with everything on all of these Santa Monica websites?" Because she was trying to set up. She's like, "It looks like I'm in the 80s." And anyway, like these, and she's coming from the Bay Area, so I don't know. I mean, I just, obviously she's similar age to me. I hope we're getting a younger group of people engaged in municipal government. It's very important. I want people to feel like they're able to make a comment. So anyway, that was an aside. I would also say, I know we didn't talk about this at all last time, and this isn't necessarily in the budget because it's not like we're going to put a position towards this, but when we talk about our goals and our analysis, we didn't talk about equity last time, and I just want to make sure that, especially with the new rent database, obviously we're serving a higher net worth and a less diverse community in Santa Monica than we are in other areas of the county. But I still want to make sure that we're looking at who are we serving when people come into our office? Where are they from? Are we able to serve people in threshold languages of Santa Monica? Is there easy access of services? And are we making sure that we're going to people where they are? And I just think we need to take an intentional look, especially, like, it's incumbent on us, right? We're government. We're supposed to be leaders. We need to lead that change. And we need to think, I think, a little bit more intentionally, instead of like as an afterthought about how we're delivering all these services with equity. So in a future meeting, I mean, I'm not saying, oh my God, a knee-jerk reaction, let's do it right now, but especially with the new rent database and better ability for tracking, would love to see some of the outcomes and then also think about how we might be able to do things better or differently. But I mean, I'm good with the budget just as you had presented it.
Thank you. Thank you.
May I just comment on that briefly? As you may have heard in the council meeting on Tuesday evening, they've given some direction for the city to look very closely at the equity issues that you've mentioned. And so the city as a whole will be doing that, and we will certainly be participating in that. Additionally, the city has the GARE program, the Government Alliance for Racial Equity. Mr. Mordezai has participated in that program. We hope that others will participate in that program in the future. And we are committed to making sure that we are providing equitable services to everybody that needs our services. And we will be working on that along with the city this year.
Thank you.
Thank you. Commissioner Foster.
Thank you, Chair. And I just want to echo Commissioner Trost's comments. All of us have been racked this year by the effects of COVID-19 and the issues surrounding equity. And I just wanted to make it a note that I think our agency has always strived to do that. And any time that I've personally asked staff or Tracy to make documents available to, say, Meals on Wheels clients in the hundreds of homes, they've done that. They've responded to those efforts. And I know that we can continue to find new ways and innovative ways to continue to do what I think staff has already been doing. And this agency has always considered to be something important, is now even more important than maybe we even realized. I said my comments last month about the budget, and nothing's changed for me from then until now. This is the public hearing, but seeing as that there's no one that has additional comment from the public, I will just once again restate that I think part of the reason they might not is that our staff has always proven to be so accurate and so careful with the funds that the landlords and tenants pay for equally in this city, and we appreciate that. Lima, Dan, all the department heads, Stephen, Tracy, Lynn, everyone runs a tight ship, and we appreciate it.
Great. Okay. Do we have a motion to approve the budget?
I move that we accept the budget.
Okay, is there a second?
I'll second.
Commissioner Foster moved. Commissioner Drawn seconded. Can we have a roll call vote, please?
Yes, Commissioner Terosis,
Yes.
Commissioner Foster,
Yes.
Commissioner Drawn,
Yes.
Commissioner Sultan,
Yes.
and Chair Phyllis.
Yes.
Motion carries.
Okay, next item on the agenda is consideration whether to amend Regulation 11-200, Subdivision D, Paragraph 1, to clarify that a business day is any day that the board is staffed and conducting business, regardless of whether City Hall is open to the public. And Paragraph 7, to provide for the deferment of registration fees with respect to units occupied by tenants who are unable to pay due to the loss of income occasioned by COVID-19. And we have a brief staff report, please.
Wait, can I ask a question before we do that? Is there any way to, well, I don't know, I guess I have a motion on the table to bifurcate discussion item 1 and 2, and eliminate discussion item 2 and Mr. Lewis, please correct me if this is incorrect. We still would proceed with discussion item 1 regardless of item 2, correct? Yeah. So
Yes, that's recommendation.
I would move that we don't need to hear a staff report on item 2, and that we would only hear on item 1. Is that proper?
I would second that if deemed proper.
Yeah, Mr. Lewis, is it proper just to hear 1 and bifurcate the 2, not hear 2?
I think he might be frozen. I couldn't tell if he was just really frozen. Now he's back. Okay.
Sorry. I wondered why everybody was staring at me so blankly. Yes, it is completely proper for the board to control its own agenda, and there's no problem with the board deciding not to consider that something that was on the agenda.
I move not to consider discussion item 2 and just to hear discussion item 1. Any seconds?
Yeah, I will second that with the caveat that in the note that there are no public speakers on it either, which gives me further comfort to second the motion.
Right. I also have no objection to this, even though I asked for this last month. We have not heard from anyone in our community who really petitioned particularly fervently for this request. Under the circumstances, I don't think it's particularly compelling to pursue it any further, so let's only hear about part one.
Do we need to have a voice vote on that or a roll call vote?
You can do, because you're not deciding something substantively, you're just deciding not to decide something, you can do that by voice vote.
Okay. All in favor?
Aye.
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 Opposed?
Brian, does he join?
Unanimous consent. Mr. Augusta is not a board member. Occasional appearances. I'm sure there are certain members of the public who are happy to hear that. Council.
All right. Staff is recommending that the board adopt a technical amendment to Regulation 11-200. The need for this amendment became apparent when reviewing the regulation in connection with the issue that the board this evening decided not to consider about the deferment of registration fees. Registration fees are due every year by no later than August 1, and under existing regulation 11-200 D1 sub 1, in years in which August 1 falls, quote, on a day of the week when the board's offices are closed to the public, unquote, fees must be paid no later than the first day after August 1 that the board's offices are open to the public. This year, August 1 falls on a Saturday, a day of the week when the board's offices are never open to the public. The next business day is August 3, and if this were any other year, we could assert with confidence that that's the day by which, under Regulation 11-200, fees would be required to be paid. But this is not any other year. This year, City Hall, and by extension the board's City Hall office, has been closed to the public since the middle of March as part of an effort to prevent the spread of COVID-19. Although it appears that the building may reopen to the public in the coming weeks, there's no guarantee that a worsening public health outlook won't lead officials to close it again in relatively short order. If the board's offices are not open to the public, quote unquote, on August 3, then under Regulation 11-200's plain language as it currently exists, registration fees will not be due. Registration fees, of course, fund the board's regulatory operation, and that operation has continued regardless of City Hall's closure. The board must be able to provide services to controlled property owners and to renters, and owners deserve clarity about their payment deadline. For those two important goals to be met, the fee payment deadline must be fixed and reliable, which it cannot be if the deadline is pegged to the first date after August 1, when City Hall is open to the public, and there is chronic uncertainty over when that will occur. To remedy this problem, staff recommends that the due date be decoupled from whether City Hall is open, and instead amend Regulation 11-200 D1 to state that fees are due on August 1 unless the offices are closed, and to clarify that the offices are closed only when they are not staffed and conducting business. The text of a full possible amendment to this provision is included in the board packet. Thank you.
Okay. Does anyone wish to speak on this item?
I move that I'm going to make a motion that we accept staff's recommendation to change the regulation as staff has just outlined in their report.
I will second that. May we have a roll call vote, please?
Yes. Commissioner Foster.
Yes.
Commissioner Drawn.
Yes.
Commissioner Salton.
Yes.
Commissioner Trosis.
Yes.
And Chair Phyllis.
Yes.
Motion carries.
Right. And now for one of our most favorite biannual, right? Biannual is, no, semi-annual? I don't know. Twice a year. Report from Mr. Augusta on what's happening in Sacramento. Mr. Augusta, although you're not a board member, we'd love to hear from you.
Thank you, Madam Chair, and I apologize for interrupting your meeting a moment ago, but I realized that the other room that I was in was growing dark, and I might turn on my camera and all I could get was a silhouette, so here I am in a different room. Very pleased to appear before you tonight and update you on the very strange, sort of much like you all are experiencing, carrying out the business of the board remotely, magnify that by 120 members of the legislature covering the entire state. Very challenging times for the public process, as you know all too well. And also very challenging times for many people in the state. And so I think for those of us who spend our time up in Sacramento, as I do on your behalf of others, to try to influence that policymaking in a time in which some very challenging moments in our state and in our country, where we need policymakers to be making tough decisions, and we need the input from the public. It has presented some real challenges to that. I'm going to talk tonight about a few things, of course, that are of interest to the board in that regard, but much of that is colored by the challenges that we face, that you face as members of the public, and as elected officials in trying to shape the policymaking in Sacramento, which is, I think, so critically important right now for both renters and landlords, because of the very unique challenges that the COVID crisis has presented to our economy and the impacts that it's having on both renters and landlords. I want to talk a little bit about that. Also want to talk a little bit about the budget, which there's not a lot of good news in the state budget, and the impacts of the COVID crisis on our budget making and on our once rosy economic outlook in California have been fairly severe, and the budget reflects that, in addition to the challenges of just putting together that budget in a process that is mostly remote. So let's start with some of the responses to the COVID crisis. You all have in front of you a board report from our firm that details a lot of the policymaking that's going on the housing front, and happy to entertain questions on any of those bills, but I wanted to focus in my brief presentation on a couple of things that I know are of the most interest to you and to the public. As I mentioned, we all know that the quick shutdown of our economy, which many agree was necessary to protect the public health, also had a tremendous impact on all kinds of folks, but particularly on renters and on low-wage workers who suddenly found themselves without months of income. And for a lot of lower-income renters who were struggling to make the rent before we entered into the COVID crisis, who were paying 70 or 80% of their income towards rent, to have that sudden loss of income, be expected to make the rent, and know that if you couldn't, you were going to fall hopelessly behind. It has been a very challenging time. And our state has taken a number of actions to try to putting a pause on evictions. The court imposed early in this crisis a emergency rule of court, which basically prohibited most eviction cases from going forward. It doesn't mean that the landlord whose tenant has not paid the rent chiefly, or has engaged in conduct that would justify an eviction, that landlord is without remedy. But for most cases, the courts were hitting pause, and that provided important protection to keep the sort of status quo of our rental housing market. And then earlier this week, so that original rule was supposed to end when the emergency order by the governor was lifted, plus 90 more days. And then earlier this week, we learned that the court was contemplating, in a very swift process, to repeal that rule effective August 2nd, which would have been very challenging timing for the legislature to put in place alternative protections for folks, or to grapple with the difficult questions that have come up about what do we do about the unpaid rent? How do we make sure that tenants are not going further into debt, but how do we also make sure that small landlords who are also struggling from the loss of potential income are also not at risk of falling into insolvency? And without any real advance notice, it looked as though the court was going to repeal that rule quite suddenly. Legislators and advocates and many other concerned folks jumped into action, and we were pleased to learn yesterday that the court has decided to hold off on repealing that rule, to give more time to the legislature, among others, to when the solutions are. So midweek, we were very concerned about what that might mean. And I'm pleased, since we sent in our written report to you, that we had some good developments on that front. But we still face very difficult, important task, which is to figure out what will we do as a state about this unprecedented event where so many will be unable to pay the rent. And we know that has an impact, as I said, on both renters and landlords. And we've got to grapple with that. Earlier this week, Assemblymember Chu introduced, effectively amended an existing bill that was in the Senate, AB 1436, but introduced new language into that bill that was public for the first time that will that tries to answer that question. And the proposal is that unpaid rent, that time period for what people are calling the COVID time period of the COVID emergency order plus additional time, additional 90 days, just like the court rule, that during that time period, the non-payment of rent cannot be the basis for an eviction action in using the unlawful detainer process, the SWIFT state process for returning possession of the property to a landlord, that instead the landlord could seek the lost rent through other remedies, but not through that SWIFT eviction action, which, as many have acknowledged, that process is chiefly set up with its short timelines of a 3-day notice and a 5-day summons, provide a SWIFT remedy to return the possession property to the landlord, not as a means of collecting a debt chiefly. And so it's not unprecedented pose that the debt itself not be part of that process or be the basis for that process. So in light of that, a broad coalition of advocates have sponsored 1436, and Chu and a number of Senate and Assembly members are co-authoring that bill. And it's just beginning in the process, so it will not actually get a hearing in the legislature until later in the year, after both houses go on their summer recess, which will begin, depending on whether it's the Assembly or Senate, sometime in the next couple of weeks, and then they'll return mid-July to resume their work until the end of August. And it's during that time period that bill will get its first hearings. But that issue is also one that has received attention in the Senate. President Pro Tem of the Senate, Senator Atkins from San Diego, announced earlier in the year that would do three things. It would do as 1436 does, to kind of change the rules about eviction for non-payment of rent, and then would create a mechanism for how we're going to handle that unpaid rent, and the concept, details of which have yet to emerge beyond basically what I'm about to describe, would be that this tenant, the unpaid rent of the tenant would be a debt of the tenant to the state. The state would provide a 10-year repayment plan and a very robust process for hardship exemptions for tenants who couldn't pay that debt, to have that debt waived. Meanwhile, for the landlord who was owed the rent, the state would provide a tax credit in over a 10-year period that would seek to compensate them for some of that unpaid rent. One of the debates in the legislature on this whole issue has been what authority does the landlord have to say, I don't want to participate in that, I want to proceed in the eviction process. I think many tenant advocates have urged that the two should be decoupled, that we should provide robust assistance to those who need it, but there should not be sort of a veto power for one party to say they're not going to participate and sort of prevent the state from achieving their goals with that process. And that would include a landlord saying, I'm not going to accept the rent payment, I'm going to evict the tenant. So that is the nature of the debate. landlord groups are particularly forceful in arguing that if the rent is going to be some portion of the rent, if they're not going to receive 100% of the rent, they should be able to essentially not participate and pursue other remedies. So that debate is ongoing, but the pro tem's proposal is one, much like 1436, which to be most protective for folks, it would need to be enacted before January 1st, which is when most legislation takes effect. So the other part of the conversation is this something that might be done as part of the budget process? There's not an indication that that's going to happen in June, but the budget process continues into August with some follow-on trailer bill language and follow-up. I think we may have lost our chair, but it looks like Mr. Trossis has a question.
Am I allowed to ask a question?
Yeah, no. I'm here. I had to walk around, but I'm here. So, hello.
Am I allowed to ask a question, Mr. Augusta?
Yeah.
So on the budget situation, so I understand from reading your memo that a potential compromise with Senator Atkins would have, in your memo that she was interested in providing some sort of tax credit relief for landlords. And you alluded to that. However, my new understanding of the budget compromise is that there's going to be a scaling back of all tax credits, period. Yes. So this is not on the table, is what you're saying, until potentially August, when you know what the HEROES Act or the scaled down HEROES Act might bring? Is that what you're saying?
Yeah, let me add some additional context to that. I was going to talk a little bit more about the budget in the next, but to your question, we'll get into some of that now. So it is true that part of the way in which the state is proposing to close its estimated $52 billion budget gap is one through sort of the aspiration that the feds will send more money. So about, I think we're counting on 15 or 19 billion more from the Fed, 15 billion more from the feds. If that doesn't materialize, then we'll have to consider additional cuts, or additional cuts will occur. But the other thing is to close some of these tax expenditures with tax credits and those sorts of things, right? One of the proposals is to cap all tax credits, so no taxpayer can claim more than $500 million in a given year. All of that is important to understand and understand the budget. On this particular item, perhaps that issue will get wrapped up into whether or not the proposal from the pro tem is viable given that structure. But my understanding from early conversations, and things may have changed since then, but my understanding from early conversations is that the way in on this year it would be on future, but necessarily be implicated in this desire to sort of scale back tax credit.
Mr. Augusta, you're breaking up a little bit and appear frozen. Oh, but you've moved slightly. We can't hear you.
Give me 1 second, I'll correct that.
Oh, you corrected it just by doing that, actually.
By standing up.
So I don't know, Commissioner, if you heard the rest of my comments there.
Unclear if we did either. Unclear where you cut off, but you definitely cut off. So let's do the last couple. Let's do the last paragraph.
Yeah, so the conclusion of those remarks were just that I haven't had a recent sort of update on what the internal thinking may be on this proposed landlord tax credit. But my understanding is that that would be in the out years, in different budget years, not this budget year, that may or may not be wrapped up in what you were asking about, Commissioner. You're on mute.
Yeah, I realize that. Thank you. That was helpful. I don't want to derail your presentation. I just had a question about that, so I'll wait till you're done for my rest of my questions.
Okay. Picking up where I think I left off, I talked about the pro tem's proposal. I was going to shift into talking a little bit about the budget. There's not a lot of good news in the state budget. I mentioned already that there's a $52 billion deficit, looking to close some of that through tax reform, potentially. There are a few things that relating to housing and homelessness and tenants' rights that may be of interest. One is that from the last housing crisis, there was litigation against some of the major banks, which resulted in a multi-state mortgage settlement, which during the Brown administration, the proceeds of which were used in ways that were later declared to be inconsistent with that settlement. And so roughly 300 million of that needed to be sort of reprogrammed. And there were many different ways in which we were all thinking that money would be used. A big portion of it is going to go to foreclosure counseling, but 31 million of it will go to provide additional resources to local legal aid programs to provide assistance and advice to low-income folks, including renters. So that's some good news. We also know that we've received several billion in federal funds under the CARES Act, and that money has to be spent very swiftly. It has to be not just encumbered, but expended by the end of the year, effectively, December 30th. One way in which we're using a significant portion of that is to try to invest in solutions to homelessness crisis. During the COVID crisis, the governor, the administration instituted Project Room Key, created opportunities to put folks who are experiencing homelessness into what had then suddenly become vacant motels primarily. And now we want to figure out as a state, how do we convert those to both keep people housed, but also turn that into additional permanent housing. And so the state is investing about 650 million, well, a few different pots, but the biggest one is 650 million in acquisition money to try to move those hotels or similar properties into sort of permanent housing that will provide longer term opportunities for folks. Connected to the COVID crisis, so that housing will be intended to sort of keep people housed and avoid the spread of COVID-19, but it also would provide permanent supportive housing for those who need it. The other thing on the sort of affordable housing production front is that last year, state had expanded the state low-income housing tax credit, which is a complement to the federal low-income housing tax credit, which remains the largest source of funding for affordable housing development. Last year, we had expanded the state credit by 500 million, and it was, at that time, a thing which could be decided year by year, and I think a lot of folks were worried that that money would go away, but the governor committed early on to continue it, and that remains the case. And there was real tax nerds who are watching a concern that that cap that I mentioned a moment ago, 5 million in for each taxpayer, would make the tax credit ineffective because taxpayers wouldn't buy the credit. But there appears to be an agreement to exempt the. But that's a really important development.
You literally.
There seems to be now.
Sorry, you say exempt nonprofit and for-profit affordable housing development, or just nonprofit, or what'd you say?
Well, the exemption would be that a tax that $5 million cap for each taxpayer, that cap would not apply to the purchase of tax credits under the low-income housing tax credit program.
Oh, sorry. Okay. Yeah. Okay. So for-profit, nonprofit doesn't matter. Got it.
It's actually about the investor. Yes. Yeah. So I think, why don't I pause there? I think those are the big picture items, and I know that where we are in tonight's agenda. I'm happy to take more questions or expand on anything we've talked about. So, Madam Chair, I'll hand it back to you.
Okay, I see that we have a very active group this evening. We'll start with Commissioner Foster. She was first in the queue. Commissioner Sultan, is your hand up? Nope. Oh, no, not up. Okay, so it'll be Commissioner Foster and then Commissioner Torosis. Commissioner Drawn, is your hand up? No. Yes. You're on mute. Unclear.
Okay.
Sure, I'll go third.
Okay, sounds great.
First of all, welcome back. I know this must be an exceptionally challenging time for you and your staff and your colleagues. I was thrilled to see SB 1190 is moving along. Do you think that that bill's going to be okay? 1482 is such a, it's a starting point. It's one of the biggest victories we've ever had in recent years for renters and protection of renters. But it was really hard to enforce. Clients and constituents I heard from were having to seek private representation in order to enforce a law. And the notion that this is a revenue neutral item that the state can provide to localities, it's a tool, is very positive. Do you see any roadblocks for that bill?
Well, I think it's worth noting that a number of the groups representing property owners are opposing it, and California Apartment Association, for example. And as you mentioned, that bill 1190 would, among other things, expressly authorize local governments to enforce violations of 1482, which was last year's rent cap and just cause bill. So the bill did get pulled into appropriations, which I think was unexpected. So we'll know a little bit more next week what its prospects are, but it remains a controversial proposal. Tenant groups strongly supporting it and landlord groups in opposition.
Thank you.
I think Nicole left us, but I'll just quickly ask, can you just clarify for me, so AB 1436, right, eviction prevention, housing stability, giving more time to pay back rent, and then on AB 828, Ting's court-ordered settlement of unpaid rent, they both seem to have similar elements, so can you just explain to me the difference and which one seems more favorable? Because I do want to then make a potential motion.
Yeah, so I think the chief difference between the simplest way, in my mind, going into great detail of differentiating the two, is that 1436 essentially says that there is not a cause of action for unlawful detainer for that unpaid rent.
Right.
That would prevent that dispute from ending up in eviction court while still giving the landlord a remedy for the debt. 828 essentially assumes that the unlawful detainer will be filed and will proceed to a judgment, gives authority to the judge to order relief other than evicting the tenant. Should be essentially a payment plan that if the tenant complies with, they can remain in possession. But if they don't comply with, they could be immediately evicted. So in some ways, although it's court ordered, it's not too much different than what a represented tenant might negotiate in a settlement of an eviction action.
But just to,
yeah,
they're in both situations, an individual, if there was a judgment entered, would get like a judgment on their credit, like a lien, some sort of hit to their credit, right? And then you're saying that AB 828 is basically giving them like another bite at the apple, saying that they can't be evicted right away, that if they agree to a payment plan, they then have the opportunity to adhere to that payment plan. Is that what I'm hearing?
Yeah, well, to add a little more clarity to that, I think 1436 does not provide any new remedy for the debt. So at the end of the day, a tenant, if a landlord pursued that debt either through the existing mechanism of an eviction action,
right,
or if 1436 is enacted through some other cause of action on the debt itself in small claims court or civil action.
Yeah.
At the end of the day, if it has no defense, yes, there would be a judgment. The main difference is circumstance in which that comes to pass. And I think for many tenants, the unlawful detainer process, which, as I mentioned earlier, is as you know, proceeds on a 3-day notice and a 5-day summons, and unrepresented tenants often don't fare well in those proceedings, is a much less favorable forum for having that discussion than civil action on a 30-day notice, which the landlord may not ultimately follow.
Absolutely. So do you think that AB 1436 has any chance here?
Yeah. Yes.
Okay.
I think, I'm sorry. Yeah.
No, go ahead.
Well, I think Mr. Chu has this bill, and the Pro Tem's office has also proposed something similar. There's obviously a lot of conversation in between that and a signed piece of legislation, and there's going to be strong opposition to it, but I'm hopeful that there will be a very robust discussion about this, because this is where the solution to all of this is going to have to center.
Yeah, totally.
What we do with this.
I mean, obviously all the bills that you highlight are important, but specifically to, the people that we are here to serve. I want to let everyone else have a comment, but I'm prepared to make a motion to direct staff to prepare a support letter, because I do on AB4, or for the board to take a support position on AB 1436 should we decide that the board, the Santa Monica Rent Control Board, wants to support this legislation. I would like to be on record as all here having supported it. So after discussion, I would be prepared to make a motion. So thank you, Mr. Augusto. That's it for me.
Thank you.
I would be prepared to second that motion. I would think, are we already supporting that as a board just by virtue of the fact that Brian is our advocate?
No, but I want to be officially recognized. I want to see, this is why I proposed a legislative agenda last year, so that if things are within our purview and they move quickly, we can quickly have staff prepare a support letter. And that's why I was also going to say in my motion, any further legislation that comes forward, if it's from Senator Atkins or Mr. Chu here, whatever the changes might be, if it's within the vein of what we had originally said we wanted to support, we still want to continue with that support position. So I know that Mr. Lewis is here probably with a comment.
Yes, I just wanted to say that because the board has already clarified what its legislative priorities are, and this is consistent with its legislative priorities, the board doesn't need to make a motion for us to do that. We would already be doing that.
Are you sending a support letter?
Well, we would be supporting it in other ways, but you don't need to make a motion for that. We're okay. Already.
I would like to be on record, though, as one of the agencies that has taken a support position on AB 1436, should Mr. Augusto find that helpful.
Yes, and I'm not suggesting that you shouldn't do that. I'm just saying that I'm just reminding the board that as Commissioner Trosis mentioned, the board has already alerted staff to its and officially adopted its legislative priorities, and staff has not forgotten what they are and continues to press for them.
Okay, thank you.
Okay, before we go to Commissioner Duran, Commissioner Trosis, is the motion on the table, or are you satisfied with?
Well, I don't know. For the record, I'd just like to move that the Santa Monica Rent Control Board support AB 1436 by Assemblymember Chu of the Eviction Prevention and Housing Stability Act, and direct our staff and Sacramento lobbyists to vociferously advocate for and do take means necessary to register our official support on this piece of legislation.
I fully support that motion. My question for council is based on the agendization of the administrative item. Is everything above board, or do we can we take that action now?
Within this, there are two answers to that. One is that it's within this subject matter of the agenda item, I believe. But two, as I mentioned, even if it were not, because we would be doing the same thing regardless of the motion, I don't see that it creates any kind of actual issue one way or the other. But again, I do believe that given the agendization of the legislative report that the entire public had access to, and the board's prior announcement of what his legislative priorities are, I don't see a brown eye violation from the board asserting its position on any of these issues.
Perfect. Awesome. I will second Commissioner Trosis's motion, unless it was already seconded. Can't remember. Okay, so we have a motion by Commissioner Trosis that will not conclude the item. Commissioner Drawn, we have not forgotten about you. We're just going to get this one out of the way. So there was a motion by Commissioner Trosis, second by Commissioner Phyllis. Have a roll call vote, please.
Yes. Commissioner Drawn?
Yes.
Commissioner Salton?
Yes.
Commissioner Foster?
Yes.
Commissioner Trosis?
Yes.
And Chair Phyllis?
Yes.
Motion carries.
All right, Commissioner Drawn, you're up.
Thank you. I just wanted to ask Mr. Augusta, where are we in terms of the season for all these legislative items? Are we? This is a baseball game. Are we in the third inning, the sixth inning, towards the end of the game?
Closer to the sixth inning, but they've changed the rules a bit. So we're going to be, what typically would happen at this time of year is that at the end of May have been moving into hearing all the bills in the second house and do the committee hearings and then take a break and come back and do the appropriations committee and the floor. This year, they're going to take that summer break and then come back and in a more compressed time frame do the policy committees, appropriations, and floor. And the other thing that I didn't mention in my presentation earlier is that in order to accommodate that press schedule, all the bills, first of all, as I mentioned, well, I guess I did mention that in my written report, but the bills, there are fewer bills, and we're only giving each bill one hearing. So it's a much different process, which may work to move bills to the floor faster, but will probably also result in a lot of last-minute negotiations on those bills. But we will still conclude at the end of August as required.
Understood. All right. Thank you. And thank you, Chair Phyllis.
Thank you,
Brian.
Brian.
Thank you so much, Mr. Augusta.
Thank you, Mr. Augusta, as always. Thank
My
you for the
pleasure.
excellent work you
Thank
do.
you so much, Brian.
Thank you all.
Okay, until 6 months from now.
Bye all.
Okay, next item on the agenda is adjournment. And before I entertain a motion, we would like to adjourn in memory of Don Rourke, who is Anastasia's father and a member of our family on the rec control board. Anastasia lost her father earlier this week. She's a testament of strength. The fact that she's still here and participating in this meeting is unbelievable. Her father was a fantastic man. He served in the U.S. Air Force, where he was a paramedic for Vietnam War veterans, where he did everything from tending to soldiers to delivering babies. He had an illustrious career in Missouri. One of his favorite places in the world was Lake of the Ozarks. He was an incredible man to create our colleague. He has a beautiful family. And we just want to express our love and support for Commissioner Foster and her family and our condolences. And it's an honor to adjourn in his memory.
Thank you very much. I'll remember that for a long time. Thank you.
We love you, and your dad is awesome. And we just, not that this is personal time now, but of course we always are wanting to honor his memory. And it's, kind of a very small gesture, and obviously what was an amazing life. And, he had a beautiful family, and we were thinking about you and your mom, obviously. May you rest in peace, and we're all thinking of you.
Thank you. He was very proud of my board service. So
Very nice.
thank you all.
Thank you all. I'll make the motion. Is there a second?
I'll second. Oh yes.
Commissioner Foster, very appropriate. Roll call vote, please.
Commissioner Sultan,
Yes.
Commissioner Duran,
Yes.
Commissioner Trosas,
Yes.
Chair Phyllis,
Yes.
and Commissioner Foster.
Okay. Good night, everyone. Stay safe.
Good night.
Everybody.